that question after all the evidence in the case has been laid, I might consider wanting to grant Ms. Lombard's legal representative to address me on the issue before final determination is made. But the primary reason is that I foresee a possibility that evidence might still be led in the next phase of this case that might impact that decision. So for the reasons that I have stated, I'm of the view that the state succeeded in proving the guilt of Mr. Apollos, Mr. Van Ryn, Ms. Smith on the main count in count 1 and on count 2. So the following order is issued. You may remain seated. On count 1, you are guilty of a contravention of section 4.1 of the Act, read with the other legislation on trafficking in persons in relation to Joshlin Smith. On count 2, you are also convicted of kidnapping in relation to that. Can I just ask the public, please just bear with us. I know that's emotional, and I understand the expression of your emotions. Let us complete our process that we need to do for now. Then I'm going to adjourn. Then you can express your emotions as you wish. You 69s? Certainly. Mr. Apollos, you must listen.
On the 27th of October 2020, there's a conviction of theft committed on the 22nd of August 2020. The sentence imposed was a fine of 10,000 rand, or 10 months imprisonment, which was wholly suspended for 3 years on condition not again convicted of theft or attempted theft. And there was also a declaration that he is unfit to possess a firearm. My Lord, that is the only conviction against accused number 1.
Mr. Apollos, do you admit the previous conviction? Good. You will be given the form to sign. And I'm not sure whether... Do you have a fingerprint pad here? You can do the fingerprint later, warrant officer. Just leave it there so long. Leave it by you so long.
My Lord, if I may then proceed, Mr. Van Ryn. On the 3rd of October 2014, convicted of 2 counts of robbery, which was committed on the 17th of March 2014. The 2 counts were taken together for purposes of sentence, and 24 months imprisonment, which was wholly suspended for a period of 3 years, on condition that he's not again convicted of robbery or attempted robbery being committed within that period. And there was 12 months correctional supervision imposed, and he was also declared unfit to possess a firearm. The next conviction is on the 17th of January 2016, also for robbery, committed on the 23rd of October 2016, and there the sentence was 2 years imprisonment. And then the next previous conviction is on the 28th of March 2018. That was a contravention of Section 4B of Act 140 of 1992, possession or use of drugs, committed on the 26th of March 2018. The fine there was 100 rand or 5 days imprisonment. My Lord, then the next one is on the 9th of December 2020, convicted of housebreaking with the intent to steal and theft, committed on the 4th of October 2020. He was sentenced to 24 months imprisonment. On the 11th of June 2021, released on parole supervision, which was supposed to be until the 8th of December 2022. There was, however, an extra endorsement where he was readmitted. The endorsement date was the 28th of October 2021 to serve the remaining portion of the sentence, 407 days imprisonment due to a violation of the parole supervision conditions. Those are the previous convictions of Mr. van Ryn.
Mr. van Ryn, do you admit your previous convictions? Thank you. All right. So whilst the administrative tasks are being performed by the constable, we now need to plan. So I'll tell you what my prima facie view is. We should maybe postpone the matter to a holding date, which will be a date, say, not this coming week, the week thereafter in Cape Town. I will deal with it early in the morning. And by that date, we will then determine whether you're going to lead any evidence in aggravation. I suspect so. Whether the defense wants to call any witnesses in mitigation, then we'll know how many witnesses we need to call. I hope nobody's going to ask me for correctional supervision report because it's not applicable. No, I'm talking to the defense already. I'm talking about correctional supervision, but we also don't know whether there are any other assessments to be done. So once we know that, we will have an idea how long it will take to compile everything, but also how long we will need for the sentencing proceedings. And then I would want to come back here, because I think it's as fair that we do it here. But all the prep work we can do whilst we're in Cape Town, it'll also give me the opportunity to, I thought I might still have to go to the office in town today. I was supposed to be in Cape Town today, in the office. But I'll see what I can arrange. So that's just my idea. How do you feel about that from the state side?
That sounds good, my Lord. The state does intend to lead some evidence. At least victim impact statements will definitely be prepared. If the defense, if I may just ask, if the defense could perhaps indicate whether they want to apply for probation officers, then we can assist. Thank you, my Lord.
Mr. Harmsen.
Obviously, defense on behalf of accused one, would need to consult with him. I am in agreement with the arrangement proposed by Your Lordship for a date in Cape Town. We obviously need to consult with accused one and then take instructions as far as the procedure further.
Will you be able to, next week Friday, will you be able to advise me by next week Friday? In other words, I can postpone the matter till Friday next week, which is the 9th of May. I doubt that I have appeals, but we will have a courtroom available, so I can do it in one of the courtrooms there. That's just for everybody to report back. This is what we want to do, so that we can start planning from there.
Yes, it sounds in agreement. I'll be in agreement with that for the 9th, yes, my Lord.
And then we can say we do it at 9 o'clock.
Yes, I am in agreement, my Lord.
Ms. Nkabai?
Morning, my Lord. I'm Kabai on behalf of Mr. Van Rijn. I would concur or concede with my learned colleagues' submissions that the matter be heard on the 9th. I have to consult with my client, and I will, on that day, explain to court what are my instructions.
Mr. Sivnarine, similar? Okay. All right. So what I'm going to do is, it's 10 to 1. Right. I'm going to clearly they must be transported to Paulsmoor. It's going to be difficult now if I issue the order now for Paulsmoor. So I'm inclined to do 2 warrants, 2 detention warrants. To authorize both places. In other words, I say at this place and or that place, so that maybe tonight they can be held closer, so that they don't have to take the R27 on a Friday in the middle of a long weekend. Otherwise, the police will only reach Paulsmoor when tonight. And they're going to hit the peak hour traffic on their way to Tokai. So I'll hear from warrant if I say Malmesbury, and then during the course of the week they can make arrangements for them to be transferred. That okay? And will it be Langebaan for Ms. Smith for tonight? That'll just it'll just make it easier, because I can foresee problems if it's too late. Also, we're not sure what time they're going to leave from here now to wherever they need to go, because there's a lot of admin to be done. I'm also aware that because we made the arrangements the other day that their parents might be here, I'm not going to make an order. It's not my place. But often what I do is, if I convict somebody, and if it is possible, I tell the court orderlies, if it's within your powers, I wouldn't have a problem if you at least have their family speak to them before you take them away. Right? But I'm not going to make an order because I don't know what the arrangements are. So the following is going to happen. Mr. Van Rijn, Mr. Apollos, I'm going to do your warrant dual, so it will be Malmesbury, Polsmoor. Ms. Smith, I'm going to do you Langebaan, Polsmoor. You will be appearing at the High Court in Cape Town on Friday. All that will happen there is I will be informed how we're going to do the process further. And it will depend on availability of witnesses, reports, and so on. And once I have that and we determine a date, we'll postpone the matter back here for a day or two. It won't take longer than 3 days, I take it, to come and finalize the matter, where I will then have to impose sentence. I want you to give your legal representatives instructions as to what you want to do, because remember, there is a prescribed sentence of life imprisonment on count 1. Just remember that, so that you don't sit back and it's your choice, but so that I have everything before me, and I know the state is going to argue for life imprisonment. So, just give your instructions. Members of the public, can you just remain calm now? I'm going to adjourn. Then give the police an opportunity to take Mr. Apollos van Rijn and Ms. Smith out of the courtroom to the holding area. And then you can quietly leave, or if you then want to clap and ululate or whatever, that's your business. Right? I'm not going to stop you, but let's give them the opportunity to do their work. And then we leave orderly. Remember, we're a big number of people in this hall. Let's leave orderly, and thank you for coming. The court will adjourn.
Well, coming back to you now from that handing down of judgment by Judge Nathan Erasmus in the Joshlin Smith case in the Western Cape High Court.